The Liberty Weekly podcast is brought to you by Tom Wood's Liberty Classroom. Sick of losing arguments with your statist friends? Fear no more. Now you can vanquish your intellectual foes with courses taught by top libertarian professors. Tool your intellectual arsenal and enroll today by navigating to www.libertyweekly.net/Liberty Classroom or by following the link in the show notes page.
Hello, everyone, and welcome back to another episode of the Liberty Weekly podcast. As always, I'm your host, Patrick McFarlane. You are currently listening to episode number 36 of the Liberty Weekly podcast, entitled Non-State Legal Systems, a Primer. The show notes for this episode may be found at libertyweekly.net/36. In this episode of the podcast, I'm going to begin tackling the immense question of how would an anarchic society institute justice? I have a few reasons for tackling this subject. One is because I am a student of the law myself, so it would only make sense that I should utilize my formal training to help the movement in this manner. Secondly is because I think that by establishing my own niche within the Liberty podcasting community, it will be easier for me to get my name out there as one of the, quote, go-to sources for answering these kinds of questions. And finally, I think that this question is an area within the theory that deserves a little more work, both scholarly and popularly. I've been consuming media in this movement for a couple of years now, and unless I'm being ignorant, which is well within the realm of possibility, I think that the liberty movement is in need of someone who communicates these ideas a bit more exclusively and a bit more popularly. Now, I do know that there are big names in the movement who work within the legal sphere, and I will humbly tip my hat to them here. This is by no means an exhaustive list, but it's merely the people that I myself am aware of. The first name that comes to mind for me is Jeff Deist, who is the president of the Mises Institute, obviously. Jeff Deist was a tax attorney for quite some time and an advisor to Ron Paul in his congressional days. Next is Mr. Stephen Kinsella, who mainly specializes in intellectual property and assorted economic issues as well. I know that Mr. Kinsella does have a podcast, which is entitled Kinsella on Liberty, but at last glance, he only posts episodes intermittently. Then there's Alan Mendenhall, who is the Associate Dean and Executive Director of the Blackstone Center for Law and Liberty at Faulkner University, but more specifically at the Thomas Good Jones School of Law at Faulkner University. That's quite a mouthful there. But he has appeared several times on the Mises Weekends podcast and has also been published in his own right on several publications, including Forbes, and obviously at the Mises Institute as well. Next, we have David D. Friedman, who is a professor of law at Santa Clara University School of Law. He is obviously very well known for writing The Machinery of Freedom, where he makes the utilitarian case for privatizing everything. I myself am not a utilitarian, so we differ in that regard. Also, David D. Friedman is not an Austrian economist, but nonetheless his analysis is astute and seminal within this sphere. Obviously, David Friedman is Milton Friedman's son, something that I'm sure irritates him when it is brought up because he's probably has lived his entire career under the shadow of his father. But nonetheless, David D. Friedman is a prolific scholar in his own right. Another figure that I have found very useful recently is Bruce L. Benson, who is currently the chair of the Department of Economics at Florida State University. He has written what I have found to be the best book on this topic, one that I'm currently reading and sourcing for this show, entitled The Enterprise of Law, Justice Without the State. And finally, we have the late Bruno Leoni, an Italian professor of legal theory and the theory of the state at the University of Pavia. He wrote a great book that I'm also working through entitled Freedom and the Law. So like I said, aside from my episodes on Lysander Spooner, this episode is going to mark a concerted trend of work in the direction of law, at least when it comes to my scripted scholarly episodes. If you would like a copy of the transcript for this episode, including hyperlinked citations, these resources are available for my Patreon supporters, along with loads of other bonus content at patreon.com/libertyweekly. But our topic today is that of defining and describing informal, traditional, and other non-state legal systems. And in order to properly introduce this topic, I will offer a loose definition of what these terms refer to. Although definitions for these systems vary, Penal Reform International defines informal justice systems as, quote, non-state systems composed of a combination of traditional justice systems, popular justice forums, and alternative dispute resolution forums. And according to that same organization, traditional justice systems are, quote, non-state justice systems which have existed, although not without change, since pre-colonial times and are generally found in rural areas. Many legal professionals in our country, that is the United States, may question the importance of such systems, seeing them as being primitive or archaic. However, the United Kingdom's Department of International Development has estimated that, quote, in many developing countries, traditional or customary legal systems account for 80% of total cases litigated, which is a very astounding number. And this tells me that without these systems, daily life would be near impossible, as these communities would have to rely on their respective states for justice, which, obviously in third world countries, these states are often openly incompetent and corrupt. And just as an aside, people have pointed out to me in Facebook arguments that maybe the prevalence of informal justice systems in developing countries is part of the reason why those countries are still developing. And to that I would say they don't really understand the nature of informal justice systems or the reasons why they exist. I would also point out that most business litigation in the Western world is done through private arbitration or through alternative dispute resolution. And I'll be sure to do an episode on this phenomenon too, but at least when it comes to informal justice systems or the third world, the problem does not involve private arbitration. It goes beyond that. So even though 80% of dispute resolution in the developing world is done privately, Miranda Forsyth notes in her paper a typology of relationships between state and non-state justice systems that, quote, despite the prevalence of non-state justice systems and the growing official and academic recognition of their existence, to date, few comparative studies have been made of them. Obviously, this quote highlights the fact that despite the massive prevalence of these systems of arbitration, it is an area in need of more study. And according to another source for this episode entitled, quote, Non-State Justice Systems and the State, Proposals for a Recognition Typology by Brynna Connolly, there are many reasons that people all over the world continue to rely on these customary legal systems. One is that despite the state and its political boundaries, many local communities retain entirely distinct cultural, legal, and moral values that often differ from the rest of the population. Another reason is that access to justice is simply not realistic in inaccessible rural areas. But the most telling reason is that in many cases the state simply cannot provide the same level of dispute resolution or is seen to be illegitimate by the populace. And again, citing Penal Reform International, Ms. Connolly lists, quote, the salient features of traditional justice systems, and I'm going to list them here. There's 12, so bear with me. The first salient feature is that disputes are seen as a problem for the whole community or group and not necessarily as being between individuals. The second feature is that there exists, quote, an emphasis on reconciliation and restoring social harmony. The third facet is that, quote, traditional arbitrators are appointed from within the community on the basis of status or lineage. The fourth is that there is a high degree of public participation in these systems. The fifth is that customary law is merely one factor considered in reaching a compromise. So that means that there is a wide range of authorities that they pull and make their decisions from. The sixth facet is that the rules of evidence and procedure are flexible. The seventh is that there is no professional legal representation in these systems. The eighth, and most important for our purposes, is that the process is voluntary and the decision of the court is based on agreement of the parties beforehand to abide by the judgment. The ninth is that there is an emphasis on restorative penalties. The 10th is that enforcement of decisions is secured through social pressure and not through coercion. The 11th is that the decision is confirmed through rituals aiming at reintegration, that is, reintegrating the parties back into society. And the final facet is that like cases need not be treated alike. Hence the informality of this system. One thing that I know and that I read in the paper is that it is difficult to predict what the courts will rule beforehand. And so that's trouble that I see arising, is that you could go and ask several different people what the punishment would be for adultery or something like that, and you would get 5 different answers. So you can't predict it, and that makes it hard to facilitate business, I would assume. But moreover, this may be an obvious point, but nonetheless, I need to make it, that these legal systems are not by any means analogous to our Western legal tradition. Neither do they comport with natural rights theories or what we would consider to be, quote, libertarian. However, a study of these legal systems can demonstrate the plausibility of entirely voluntary legal systems that are enforced either by market mechanisms or through social and community pressure. To frame community involvement that exists under informal or traditional legal systems, I think I have to also take a moment to explain an important concept in understanding the 2 different legal systems that exist in the West, that of the adversarial system and the inquisitorial system of justice, the latter of which would perhaps be more representative of these informal systems. Audience members that live in the United States or the United Kingdom will be most familiar with the adversarial system, which the 10th edition of Black's Law Dictionary defines as, quote, a procedural system such as the Anglo-American legal system, involving active and unhindered parties contesting with each other to put forth a case before an independent decision-maker. Likewise, the 10th edition of Black's Law Dictionary defines an inquisitorial system thusly, quote, a system of proof-taking used in civil law, whereby the judge conducts the trial, determines what questions to ask, and defines the scope and the extent of the inquiry. This system prevails in most of continental Europe, in Japan, and in Central and South America. So parsing through that definition a bit, I talked about the difference between common and civil law systems in episode 28 of the podcast, entitled Liberty Weekly and the Constitution of No Authority, which may be found for your consumption at libertyweekly.net/28. But also, given the community-centric features of these informal systems and the high degree of public involvement, it would seem that these informal systems do not neatly fit the inquisitorial adversarial dichotomy. If anything, though, I would think that they would lean more inquisitorial than they would adversarial. But moreover, in the Anglo-American tradition, we have centered our legal system around this idea of adversary parties, thinking that that competition will more often bear the truth better than community involvement or a third-party inquisition. Since these informal systems view any given dispute as an issue that involves the entire community, it would appear that they do not comport with themes of individualism, as I mentioned earlier. However, that does not mean that there's nothing to be learned here. And I mentioned earlier as well that most of arbitration in the business world, in the Western world at least, is done privately. That would be more representative of our individualist tendencies in the West, and that's something that I will explore in future episodes about that facet of litigation in the West, private arbitration, that is. But moreover, I'm going to quote a big block quote here from Ms. Connelly's article. She elaborates that, quote, such non-state mechanisms in many cases allow for participatory justice and communal ownership. They may also be highly efficient. The often familiar and informal nature of local dispute resolution facilitates efficient disposition of cases without the level of training required for the formal justice system. For similar reasons, they may often entail lower operating costs. The communal ownership of the non-state justice systems and the frequently high levels of participation may significantly facilitate the process of reconciliation in a way that formal trials cannot. Additionally, the type of justice promoted by traditional justice systems may be the most appropriate option for local communities whose members must continue to live closely with their neighbors, particularly when the infraction is relatively minor. The non-custodial nature of sanctions reduces the burden on the penal system. Their participatory nature serves to educate the whole community, and in many cases may result in a more appropriate, individualized, or comprehensive resolution to the conflict. The non-governmental nature of many traditional forms of dispute resolution may engender trust in the community, particularly where the government has been highly implicated in the history of conflict, such as in Rwanda. So that was a big block quote from Ms. Conloy's article, but let's deconstruct it from a voluntarist perspective. First off, it's quite possible that these tribes have no concept of property. So in a certain sense, it's like comparing apples and oranges. But also, I think it's very interesting that despite the community involvement and the communal nature of solving disputes in this way, it still can produce a result that is more individualized than what the state has to offer. So that's an interesting caveat there. Secondly, the fact that these courts are more efficient is probably more a reflection of the inherent inefficiency of the state than it is a reflection of their own efficiency. Right off the bat, these informal legal systems are not compulsorily funded, and in many cases probably depend on philanthropy, volunteerism, and positions attained via social respect and honor. Therefore, the people involved have more accountability than state actors would in a coercive system. Finally, through reading Ms. Conloy's paper, it appears to me that these systems exist mostly because the state is either unable to provide a preferable alternative, unable to restrict these informal systems, or these systems are allowed to exist parallel to the state's models, and we'll have more on that in just a minute. But that being said, given the discrepancies between different legal systems, Ms. Miranda Forsyth seeks to classify them based on their relationship with the state. In her above-cited paper, she presents 7 different models of classification, drawing from 20 different jurisdictions that she studied personally. These models progress on a spectrum from informality to formality, based on the degree of state acceptance and integration. I'll list them here. 1, the first one being the most informal, is where there is repression of non-state justice systems by the state system. The second category is that there is no formal recognition, but tacit acceptance by the state of the non-state justice system. In the third category, there is no formal recognition of the non-state justice system, but active encouragement of the non-state system by the state. And in the fourth, there is limited formal recognition by the state of the exercise of jurisdictions by a non-state system. In the fifth category, there is formal recognition by the state of an exclusive jurisdiction inside a defined area, where only the non-state system has power. In the sixth category, the state recognizes the right of non-state justice systems and will even lend its coercive powers to it. And this would create a non-voluntary extra-state system, which I would assert is merely an extension of the state itself. And I believe that Ms. Forsyth does make that comparison as well. But the seventh and final category is that there is complete incorporation of the non-state justice system by the state. And that concludes the categories that she came up with.
However, Ms. Forsyth makes a few interesting observations about these classifications. The first is that many of the models contain within themselves a significant range of relationships, and for this reason, they should be viewed as existing on a spectrum, where one model generally fuses into another as the detail of the actual operation of the relationship is worked out. However, there are some bright line rules, despite that note that she makes. One of them is that when a state decides to recognize the authority of an informal system, usually at this level, the state has behind-the-scenes influence in its operations. The second note that she makes is that when the state goes so far as to lend its own coercive powers to an informal system, it fundamentally changes the nature of the informal system, especially where that system derives its own power and authority to make decisions. The third point that she makes is that her model obviously defines these systems by their relationship to the state, and thus makes the assumption that there will always be a state. She notes, quote, "However, because of the way the international system of granting states sovereignty over lawmaking works today, there is no jurisdiction where state law does not at least have theoretical capacity to regulate local disputes." The fourth point that she makes is that it is possible that there may be two or more different models of relationships in existence in one country at the same time. She offers the example of the Shalish system employed in Bangladesh, where the state's involvement in Shalish courts sprouted informal extra-state Shalish courts outside of the state's involvement within the informal system. And how's that for agorism there? I think that's such a cool example right there. The fifth point that she makes is, I think, one of the most important points, stating that, quote, "It is not necessary for there to be a uniform relationship between the state and non-state justice systems throughout the jurisdiction, but different relationships may be formed depending on the various needs and resources in particular localities. This just highlights the large degree of flexibility with which different societies can solve legal disputes, and frankly, I think this is an example of spontaneous order." But to that note, one of the biggest counter-arguments that I usually get from people when presented these ideas is that they cannot imagine a system by which there are more than one set of laws competing within the same geographic area. And this objection, in my opinion, is very ignorant, seeing that that is literally the norm within the American Federalist system, where townships, counties, states, and the federal government share lawmaking authority within the same physical locations. And yes, they are designated different jurisdictions, and I would say that the state has, or these state bodies, the governmental bodies, they have monopoly jurisdiction within their own confines. So the state has police powers, or at least they did at the founding. The state had police powers to deal with criminal acts within its boundaries. But these jurisdictions, they interact in certain ways, and sometimes the laws themselves will clash. But that is literally why we have court cases, and that's why we have set up the judicial system. There is protocol for when these laws clash, and chaos does not reign. And in fact, most of what courts do is to try and decide which set of rules applies and which jurisdiction is authoritative in a given dispute. And I have supreme confidence in a court's ability to decide these issues, because that is literally the purpose of having a court system in the first place. Now, I'm going to bring this episode to a close today. This is just my first introductory primer, my first foray into this topic. But in the future, I really want to do a series examining different informal legal systems using this classification system set forth above and examining it through a voluntarist lens. And I think that that will be pretty enlightening and pretty useful for us to use in our arguments and in our theoretical musings, so to speak. But in the meantime, I hope that this episode was able to shed a little bit of light on the existence of informal legal systems, introducing their relationship with the state and establishing the fact that voluntary, non-state, and private means of dispute resolution not only exist, but are prevalent both inside and outside of the Western legal tradition. For more content like this, and for interviews and discussion episodes, be sure to subscribe to the Liberty Weekly podcast on either iTunes, Stitcher, Google Play Music, or on YouTube or BitChute, or wherever else fine podcasts are distributed. New episodes usually drop on Sundays and Thursdays. Now again, you may find the show notes for this episode at libertyweekly.net/36. And finally, to support my work and gain access to a boatload of show perks like access to the Liberty Weekly meme cache, or access to Actual Anarchy's Rothbard repository, and show extras, and tons of other bonuses, please navigate to patreon.com/libertyweekly. Now, many thanks, everyone. I really appreciate you listening to my content here. Until next time.
The Liberty Weekly podcast is brought to you by Tom Wood's Liberty Classroom. Sick of losing arguments with your statist friends? Fear no more. Now you can vanquish your intellectual foes with courses taught by top libertarian professors. Tool your intellectual arsenal and enroll today by navigating to www.libertyweekly.net/Liberty Classroom or by following the link in the show notes page.